Good afternoon, everyone. Welcome to this session of the Iowa Court of Appeals oral arguments. My name is Judge Mary Chikelli, and it is my privilege to be presiding today along with my colleagues, Judges Buller and Langholz. At this time, we're going to be launching into three cases for this session. The first case of which is Burton versus the City of Iowa Falls, Iowa. It's case number 250214. The appellant is represented by Attorney Gary Dickey, and the appellee is represented by Attorney Eric Updegraff. All right, Mr. Dickey, at this time, are you ready to proceed?
Yes.
All right, whenever you're ready.
Court, I'm Gary Dickey, appearing on behalf of Mackenzie Burton and other plaintiffs, asking this court to reverse the district court's grant of summary judgment as to their reasonable notice claim, along with the district court's mandatory joiner of the open meetings claims asserted in this case with open meetings claims asserted in another case. At a 50,000-foot level, there are two grounds for reversal. The first is that a genuine issue of material fact exists with respect to whether the city provided reasonable notice in terms of whether it published its agenda in an area of the building in which the public had access or on a bulletin board as required under section 21.4. Second, the court had no authority to require joinder of the claims in this case, which arise from the July 24th meeting with the open meetings violation claims in another case which stemmed from the meeting on July 17th.
Yeah, I have a really quick question for you just as a preliminary matter. With regard to the notice issue, there was some discussion in both briefs with regard to notice being posted on a website. I think as I kind of parse through the briefs, it looks like nobody's really saying that that was the reasonable notice that everybody's talking about. The reasonable notice that you're complaining about and that's being argued is with regard to what was posted physically within the city building. Is that accurate?
And your question gets to the heart of the misunderstanding of the district court. The district court just simply misunderstood what the issues were. So in our petition, we asked for civil damages, statutory damages, which are available under 21.6 if a member of the city council has knowingly participated in the violation. There is a defense to those statutory damages, which is they do not apply if that council member acted with good faith. And so in their motion for summary judgment, they were saying that there is no genuine issue of material fact as to good faith. On the issue of good faith, we pointed out evidence of the irregularity in the way in which they posted the meeting notice, one of which was the failure to put it on the website. So we are not saying that the statute requires that they post it on the website. What we were saying is they have a regular practice of posting these notices on the website. And from the fact that they did not post it on the website on July 24th, that's a fact from which the fact finder could infer bad faith or, on the other side of the coin, the absence of good faith.
There are some facts that would lend themselves to a summary judgment finding of good faith.
Certainly not that was identified in their brief here.
Okay, do you concede there is some combination of facts that would, or is it always a fact question? That's what I'm asking.
I think if there was evidence in the record that they asked the city manager to put up notice and the city manager says, according to our policy, this is how we always do it, or if they asked the city attorney. Now, there is an exemption if there's a written guidance, but if they asked for oral guidance and they said orally, go ahead and do it that way, it's probably good faith in the absence of other facts. So those facts alone could render good faith as a matter of law.
Go ahead.
I don't think there is. I think there's a question of fact.
As I understand your argument of disputed fact, though, it's pretty narrow on the bulletin board issue and where it is, and I think you've got some good authority sort of backing that up. What I'm struggling with is kind of air preservation. I mean, I saw that argument in your brief, sort of, like not as its own heading to the district court. But then the district court, as you pointed out, seemed to misunderstand and decided this website question. So do we have a decision, without, a 904 motion that said, hey, you overlooked what we were actually arguing? Or how do we wrestle with that?
So I think the issue was clearly decided by the court. Now, I would note, we did file a motion to reconsider in the other case. I couldn't file it in this case because it was dismissed, and you run the risk that if you don't get a ruling on the motion to reconsider, then you lose the ability to appeal in this case. So,
did that reconsideration motion touch on this issue?
yes, and it's stayed pending the outcome of this case. So, the vehicle by which to file a motion to reconsider when the case has been consolidated with another and dismissed is limited. I think clearly our brief put the court on notice of what the issue is, and if the court swings and misses, I don't think that that's a waiver on our part.
Can I ask a question about the joinder issue? And I think I understand the legal basis of it, but is it independently reversible? In other words, is there prejudice to the incorrect joinder that would entitle you to reversal other than just the fact they were joined?
Yes. So this is not just an academic exercise, so the prejudice is real. So we have sought, in addition to statutory damages under Section 21.6, we're seeking removal, because Iowa is a 2 strikes and you're out state. And so under 21.6, if there is a finding of a violation of Chapter 21 that has been preceded by an award of damages in another case, then removal is mandatory. And so we sought to avail ourselves of 21.6 by filing separate cases, also because they arise from separate meeting notices and separate meetings. Had we brought those together in the same case, then Olinger versus Smith, as my friend on the other side correctly points out, we would not have been able to have the remedy of removal under 21.6, because multiple violations in a single case doesn't trigger the statutory language. You need a finding, assessment of damages, and then you need a subsequent finding. And so by collapsing this case into a single case, Judge Curry took that remedy off the table. And that's kind of important for a whole host of reasons, but that's why consolidation, to the extent maybe that's what was in Judge Curry's mind, would not be appropriate either, because we would be prejudiced under consolidation, which under the terms of the rule, you can't consolidate if one party is prejudiced. So with Judge Langholz, you talked about the fact issue in I think you were alluding to the Postville decision, which is the authority on which we rely, which states, I think, pretty clearly that just merely asserting in a motion for summary judgment that we put the meeting notice in a public place doesn't satisfy the statutory requirements, which are pretty clear that the city either has to put it on a bulletin board or put it in a place that is reasonably accessible, calculated to provide reasonable notice. And the city administrator was pretty clear, if you parse what his language is, what he said and what he did not say. He was very specific to say that they put it in a public place, but also as equally specific not to say that they put it in a place that was reasonably accessible to the public. And, frankly, his hands were kind of tied with respect to that, because in the Iowa Public Information Board informal resolution, he admitted as much, that he didn't know whether or not it was published in a place where the public had access to see it. So, the district court misunderstood the nature of their motion, which was on the limited issue of whether good faith existed, which of course only comes into play if there's already been a determination that there's an open meetings violation, because it's a defense to statutory damages. And then the court took that as a basis to dismiss the claim in its entirety, which was not what they were seeking and not the factual basis for the substance of our claim.
Going back kind of to the joinder issue, as I read the district court's order, it seems like in addition to joining the two cases together, it also granted summary judgment on your claim for removal, saying that that doesn't succeed regardless of whether they're together or not, because the closeness in time and such. Is that how you read the district court's order, and are you challenging that aspect of the order too?
So that's not how I read it. As I read it, the district court recognizes that removal is appropriate if there are subsequent cases. But since they are combined into a single case, then it falls squarely under Ollinger. And I guess I would concede, if we lose joinder and the court keeps this as a single case and all three of the open meetings violations, they get to constructively put them together in a single petition, then yeah, Ollinger controls and we don't get that remedy under 21.6. But of course, there's no textual basis, there's no rule, and for good reason, because the plaintiff has permissive joinder capability and authority, but it's not required. And if it is required, the remedy is dismissal of the subsequent action through res judicata. It's not constructive joinder.
All right. Thank you, Mr. Dickey. I see that you're out of time. You'll have 5 more minutes on rebuttal. Mr. Updegraff, are you prepared to proceed?
May it please the court, my name is Eric Updegraff. I represent the various city council members and the city council for the city of Iowa Falls. I'll start right where we left off. Let's talk about the joinder issue. Our claim here is that there is a rule that requires you to bring in one lawsuit, all of the claims that are ripe at that point, that if you could bring it, that you must bring it, and that is res judicata claim preclusion. In this particular circumstance, the plaintiffs filed a lawsuit, 2 lawsuits on the same day, within 5 minutes of each other, in an attempt to manufacture a serial judgment. There would be judgment in case 119, which would then have the award of damages to fit the predicate of having a prior violation with damages awarded so that there could be a removal in case 120. And it's CV 102, 119, and 120. I'm going to refer to them as 119 and 120. The problem with that is that both of those claims were ripe on January 23rd, 2024, when they were filed. They both could have been brought in the same case. And as Justice Mansfield explained to me at length in 2016 in the Villarreal case, if you could have brought it, you have to bring it. That we are not going to have the rules on res judicata claim preclusion be willy-nilly anymore.
Remind the statute's purpose of punishing repeat violators?
No, I don't think it does, because I think the statute it was written because it's recently been amended. The statute as it's written is designed to have this idea that you've been punished for this once before and then you violate the law again. Not that you catch somebody twice doing the same thing, because that's what the new statute says.
Different language used like in the habitual offender provision that requires the judgment be rendered in the prior action before we impose the sort of recidivist or second penalty. And that's not in the Chapter 22 provision, right?
I think we're in Chapter 21, but I'm not. I'm not familiar. I'm not a criminal attorney with recidivism as an issue. But as I see it here, is you have a civil penalty, and that civil penalty to have removal has to have been awarded against you, and then you commit a second violation. That's why they had to remove that language when they made their amendment this year. They changed that subsection D to remove the language and just said if there are 2 violations.
What's your best authority that the district court has any authority to dismiss a case and combine it together under the joinder rule?
See, I'm not seeking joinder. What I said is that the plaintiff was required to either consolidate their case or that 120 had to be dismissed under res judicata.
The district court didn't consolidate, did it?
It did consolidate.
Joinder statute, joinder rule.
Either one. But the idea being that my position is that the plaintiff could not maintain these as 2 separate actions. They either had to be one action or the second action had to be dismissed after the first action was decided. Because as we were sitting down to try and plan this trial, we were talking about having joint evidence and then having a ruling in 119 so that we could then have a trial in 120 as to whether or not there was a separate violation after the award of damages in 119. And that's what res judicata prevents. You can't split your causes of action to get yourself a benefit. That's very much what Villarreal was about, for instance, where I had a case for breach of contract and I had a case for bad faith, which rely on different facts, different legal standards, and have different damages. And I was told since they were both ripe at the same time, they have to be brought at the same time.
level, do you think joinder and consolidation are the same thing or different things?
They end up in the same place with one case, right? I mean, joinder, I believe, this is one of the things that we argued at the district court. Joinder is a voluntary concept that the plaintiff can engage in themselves. Consolidation, as I read it under Rule 1.913, is something that's in the discretion of the court. I believe that Mr. Dickey is correct when he says the plaintiff is in fact the master of their own pleadings. They could file two separate lawsuits, but they do so at the risk of res judicata claim preclusion. And that is what I brought to the attention of the court, is that we don't need to wait until you rule in 119 for me to make a motion in 120 that res judicata claim preclusion exists. You can either join these cases, or they can join these cases voluntarily, or you can dismiss 120 right now because they won't be separate. So that the
Authority, though, for the use of claim preclusion before there's a final judgment, like that, the concept's just not computing for me.
I don't. And that's because it's very rare that I run into anything where you have a predicate conviction or ruling or assessment of damages in a previous case before I get there. I was just working through, because we are in this construct that the plaintiffs created, where they filed two separate lawsuits about agenda items that are 7 days apart on exactly the same issues, on the exactly same things. I think those are lawsuits that have to be brought together. The plaintiffs elected to create this construct where they were going to file those lawsuits separately so that they could attempt to get removal. They've made that clear here. So my only response, because Mr. Dickey said to the district court, well, you should have moved for mandatory joinder. I said, I'm not aware that I could move for mandatory joinder. I don't think I could. Could I move for a consolidation? Sure. But from my perspective, the right answer is claims preclusion. Now, I could have waited to make my claims preclusion argument after 119, but I think that that's judicially inefficient. Because after all, I would have had all of us get ready for 120 and the removal issue, which seems to be a big issue for the plaintiffs, and then sprung it on the court right there in the courtroom on the day of trial. That's why I filed the motion for summary judgment. So you have to figure this out. Are these the same claims? Does claim preclusion apply? And the court determined that it did. And that's why the district court dismissed the removal claim and then consolidated the remaining claims. Because there's no prejudice.
At this point, what's your reading of what the district court did? Did it dismiss the removal claim, and is that independent or related to the joinder? Like, are both of those issues before us separately?
I think the district court dismissed the removal claim and then consolidated the remaining claims. That's my reading of the order, because that's the position I took before that court. The second issue I want to address is the claim that I did not ask for a complete dismissal of 120. I did. It's on pages 22 through 23 of my brief. It says there's no genuine issue of material fact. You should dismiss all allegations. I will acknowledge on page 25 of my brief before the district court, I asked for the dismissal of the claims for damages, and I also, and alternatively, asked for dismissal based on good faith. But on pages 22 through 23, I made it very clear I was seeking a dismissal of the entirety of 120 based on a lack of a genuine issue of material fact. And I did that because the petition in 120, if you read it carefully, only has one factual allegation alleging that there was a violation of the open meetings law here, and that is the late posting to the website. There are no facts in that petition that I was able to discern that said, well, we have a problem with it being on the bulletin board. And I believe that's the answer, Judge Langholz, to your question as to why there's not a motion to reconsider here, is because it was not raised originally in the petition. Now, I could be wrong, and Mr. Dickey obviously has the opportunity to stand up here and tell me where in his petition there was an allegation other than there was a late posting to the website when it comes to the timeliness of the issue on the July 24th agenda. But I moved for summary judgment on that issue because, in fact, the law does not require that you have a timely posting on a website.
Counsel, the petition says in paragraph 27, defendants, failed to provide sufficient and timely notice in advance of the July 24th Iowa Falls City Council meeting. I mean, we just have notice pleading in the state, so why did they have to specify website or bulletin board?
Notice requires not just a recitation of the legal standards, but also the facts on which your claim is based, so they can defend them. And I think that those weren't presented to the district court, and they weren't presented in a motion to reconsider. And we now have a circumstance where we have the plaintiffs claiming, you misunderstood my claim, and it shouldn't have been dismissed. I mean, there could have been an amendment to the petition if I'm wrong about those factual allegations, but that's what I moved for summary judgment on, because that was what was before the court. And I know there's some discussions about whether or not I've failed to do that, but I believe I have done it accurately on the petition that was before that court. And I don't recall in the resistance seeing, no, actually our claim was actually this thing about the bulletin board. Instead, and regardless, if you were going to consider the bulletin board issue, I think the burden of proof of showing a closed session lies on the plaintiff. I mean, too often we read this portion of 21 that says once there's been a showing of a closed session, then it's on the government entity to demonstrate that there's compliance. Yeah, but that's a burden shifting. Did the burden shift in this case? Was there any evidence presented by the plaintiff that the bulletin board was inadequate? In Postville there was. It's at the very start. The very start of Postville, they describe the undisputed facts that were considered. They say the city bases its claim on the fact the commission posted its meeting notice on a bulletin board located on the hallway of the commission's Postville office. The bulletin board is approximately 30 to 40 feet from the main public access door. The bulletin board is not visible from the entrance door to the office. The office is open to the public Monday through Friday, 8 a.m. till 4:30. These facts are undisputed in the record.
At this point, you're out of time, sir. Thank you. Mr. Dickey, any rebuttal?
Judge Langholz, I do want to pick up on my answer to your air preservation question. So I went back and read their brief. They've stipulated that air is preserved with respect to the dismissal of the reasonable notice claim. So I would also point out that when the court consolidated this case, I had no ability to file anything further because the case number was consolidated. So the motion to reconsider is in the other case, which I think preserves air. So
Was it stayed before the court ruled on the 904 motion?
it's still pending in abeyance because it's essentially these issues that we're raising here. With respect, as I understand it now, they are maybe arguing air preservation with respect to the reasonable notice claim. Docket number 16 at page 11, we specifically cited the Postville case and that the basis of our resistance was that they have the obligation as the moving party in summary judgment to show the absence of a genuine issue of material fact, and simply saying that you have posted a notice in a public building doesn't satisfy that burden under Postville. Judge Allers uses the example of, getting the serve over the net. And so as the moving party, they're obligated to have their initial serve over the net before we even volley. And the bare assertion that they posted the notice in a public building doesn't get the ball over the net, entitling them to summary judgment. With respect to the joinder issue, as I understand my friend's argument, they've conceded error, that the court below joined these claims. There's no textual basis, there's no statutory basis, there's no rule basis for that. Indeed, I think they're now arguing for consolidation. So at a minimum, the joinder should be reversed based on their own argument, which then opens the door to the issue of removal. I mean, those were part and parcel.
So, the district court, a lot of the district court's language sounded an awful lot like consolidation. What would be the practical problem with saying, well, effectively the court consolidated rather than joined, and it was within its rights to do that, and so we affirm that?
Well, so first of all, because I never got an opportunity to object. Second is, as I indicated to Judge Bowler, we're prejudiced by that because it takes the Rule 21.6 removal remedy off of the table. But as a practical matter, and this is really important textually, the rule for consolidation only essentially is an administrative tool. It doesn't consolidate substantively cases. What it does, it says if you have claims that arise from the same fact, you just try them in a single trial. That does not entitle them to a single judgment on the claims. So even under consolidation, we just have the witnesses testify a single time, but we are still entitled to judgments under 119 and to 120, which opens the door to the removal remedy under 21.6.
Theory of consolidation, as you've described it, then both case numbers would stay open, right? And they would proceed apace.
Correct. And, frankly, we did not resist consolidation of pretrial matters. It doesn't make sense to depose somebody in 119 and then turn around, put them under oath, and ask them the same questions under 120. Now, to the extent they rely upon res judicata, again, I track with you, Judge Langholtz. I don't understand it because you have to have a final decision on res judicata, and the remedy is a dismissal. And so they're like seeking this merits determination of issue preclusion, and frankly, I don't understand it. Now, when they cite Villarreal, and that seems to be their golden ticket that they rely upon, Villarreal was a case in which the plaintiff sued for a fire loss for breach of contract for failure to pay an insurance claim. Then when they got their remedy there, they turned around and went for punitive damages for bad faith. And the court says, you don't get a second day of court to try to litigate and get more relief from the same claim. Now, this is fundamentally different because we have 2 meeting notices on different dates. So the analogy under Villarreal would be if 1 week the restaurant burned because of a fire, and then the next week, they had another structure in the parking lot burn for a fire. I don't think anybody would argue that Villarreal says that issue preclusion prevents, different claims arising from those losses.
As a practical matter, if we reverse on the joinder/consolidation question, do we need to reach the remedies question and Olinger, or do we just vacate that portion of the ruling and say that's a problem for further down the road?
I don't think you need to reach the remedies question because I don't think I've asked you to reach it, and I don't understand that they've asked you to reach it. And I think if the court tells the district court you've got 2 separate cases, Olinger's out the window, and the court would recognize that. Thank you.
And thank you both for your briefs as well as for your arguments here this afternoon. We will consider this matter submitted, and we will get a ruling out as soon as we are able.